Aditya, and my topic is the current state of Indian public sector banks and the reforms. So, with the piles of bad loans, Indian banks are seeming to win the wrong race. The bad loans, or we call stressed loans or non performing assets, are nothing but loans on which the borrower has defaulted or it has been restructured. So, these names everyone might have come across these days because uh, billions of money has been borrowed by people and they have defaulted, like Nirav Modi cases recently. So the non-performing assets accumulated by Indian lenders are even higher than those of the banks in most major economies, including the United States, United Kingdom, China, and Japan. India ranks fifth out of 39 major world economies plagued by bad loans, according to a report by Care Ratings, unfortunately. The government has made it to a top priority to lift banks out of this extant non performing asset crisis and revive the lending growth, which also stand at 25-year low right now. As for a robust business cycle, the credit cycle is extremely important. So, to bring down NPAs, the government issued ordinances and plans to introduce more. So, among which I'll start with first is Insolvency and Bankruptcy Code, which is a very important bill required to be in place. This bankruptcy law actually consolidated all the laws related to insolvency in India by creating a single law. So, according to the statistics, nearly 60,000 bankruptcy cases are pending in Indian courts, and it takes 4.3 years for a company to shut down its operations in India. So, as with this, we can see that there are huge exit barriers, which in fact even are detrimental for the foreign investors to invest in India. This bill is going to reduce the time taken f- uh, so long time taken to 1 year, and the processes will be expedited. But as after the implementation of this code, we have seen that uh, after the incorporation of insolvency code, the lenders are taking huge haircuts after the NCLT proceedings for insolvencies. So the second reform which I'm going to talk about right now, which in 2017 the bill was passed, which is Banking Regulation Ordinance Amendment. So this bill basically empowers the Reserve Bank of India to give directions to the banks to act against the loan defaulters. The Banking Regulation Ordinance is seeking to amend the previous one and gave away to the bill, permitting the Reserve Bank of India to direct any bank to initiate insolvency proceedings and give directions for resolution of stressed assets. So another reforms which government is planning to push is Financial Resolution and Deposit Insurance Bill, which is acronym is FRDI. This bill is tentatively scheduled to come up for discussion in the passing in monsoon season of Parliament. The FRDI bill is part of a larger and more comprehensive approach by the centre towards the systematic resolution of all financial firms, such as banks, insurance companies, and other financial intermediaries. The bill comes together with the Insolvency and Bankruptcy Code in order to spell out the procedure for the winding up or revival of an ailing company. The bill provides for the setting up of a resolution corporation to replace the existing Deposit Insurance and Credit Guarantee Corporation, which will be tasked with monitoring financial firms, anticipating their risk of failure, taking corrective action, and resolving them in case of failure. And the recent bill which was passed, considering the recent cases of people uh, going abroad after getting involved into or basically declared as a economic offender. So the law is Fugitive Economic Offenders Bill. So this bill aims to stop economic offenders who leave the country to avoid the due process. So offences involving amounts of rupees 100 crore or more fall under this the purview of this law. The court, as per this law, will issue a notice to the person named as fugitive economic offender within 6 weeks from the due of notice. The person will have to present themselves at a specified place at a specified time. If the offender fails to do so, they will be declared a fugitive economic offender, and their properties as listed in the director's application will be confiscated. So these are the laws and the reforms and the frameworks which are coming into the place after the NPA problem, which is becoming larger and larger in Indian banking sector, especially the PSUs. So far, it is hard to say that how largely these reforms will be able to strengthen the current state of public sector banks. The nationalization was basically done to safeguard the poor, rather, or I would say farmers, as the proportion of the loan disbursements during pre-nationalization periods was continuously deteriorating as the favoritism to business houses was very much prevalent. Now, after talking about the reforms which are coming into the place in Indian law, the other measures which can also be considered to effectively improve the state of public banks could be that the government involvement intervention should be minimized, and based on the growth and productivity, the to and try to remove the bureaucracy and the hierarchical governance by privatization of the banks, and setting up a strong regulator. This may lead to fill the voids of inefficiency and the leakages. Thank you so much.